I'm very happy to be here today. Let me, before I begin, I would like to say that this is a wonderful seminar, and everybody here that's put it on, especially the students, you ought to know what a special thing this is that you get to do. Right now you're really involved in other things in law school, so you don't maybe realize this, but once you get out in the real world and have to start billing by the hour, you're going to realize that this is this is a great experience that you got to have. So special thanks ought to go out to Professor Beyer and everybody that's helped me get here today. I appreciate that also. I am currently the chair of the Reptile Estate and Trust Legislative Affairs Committee. So we'll call that ETLAC for short. So what the Real Estate and Probate and Trust Law section is one of our State Bar Texas sections that deals with, among other things, real estate issues, but we're here and I'm here today because of the way it deals with probate and trust law issues. And so every session there is going to be a package that is often going to be submitted and that we try to get passed during the legislative session. I'm not a lobbyist, I'm just a practitioner like many other speakers here today, but sometimes I get to feel like I am a lobbyist, and I am very thankful that I am not a lobbyist because you get to meet a lot of interesting people over at the Capitol. The session has just begun, and in fact, next Friday is going to be the deadline for filing bills. So this paper is a work in progress, and it's so fresh off the presses, we don't even have a title for it yet. So if anybody wants to give a great title, feel free to email that to me. So we're still in the beginning stages of the session. This paper is going to change because this paper right now lists all the bills that are currently been filed that might somehow or another affect what we all do for a living. And many of those bills are bad bills and they're going to go away. Many of them are good bills and they're going to go away. And other bills might be tweaked and modified, so there's going to be revisions along the way. But I know that everybody's on the edge of their seat, and I will tell you this, that the western honeybee has been named the official pollinator of the state of Texas. So that we know. Everything else is pretty much up for grabs. So let me tell you first a little bit about how the process works and why Reptile even gets involved with this. And for those attorneys out there who are not already a member of Reptile, you need to be a member of Reptile. Not only does it give you access to the Reptile Reporter that Professor Beyer is the editor of, but it also gives you access to a big database full of CLEs that are done both by the State Bar and UT and any other source that we can get papers from. And what Reptile does is we meet several times during the year as a council to come up with a legislative package and deal with other things also, but the legislative package seems to take up the biggest part of our meetings. And so what will happen is that at the end of a legislative session, say this year, sometime in July or August, Reptile will meet and say, hey, what should we do for the next session? And then we spend several meetings trying to iron out what the package ought to be, what we think needs to be changed in the trust code or in the estates code, so that we can have something to recommend. We put that together, we turn that into a bill form, and then we recommend that to the State Bar's Legislation Policy Committee. And then if it passes that committee, then our package gets approved by the full State Bar. And then if it gets approved by the full State Bar, at that point we know that we've got a green light to go forward and try to create or amend some new laws. And so what we do then is we have to send our proposal over to the Legislative Council. And what the Legislative Council is it's the part of the legislature that drafts all the bills. You know, they've got these big handbooks that show when you should use shall instead of may, and all the formatting has to be used so that everything is cohesive enough to make sense. And so they get what we have prepared and they turn it into something else. And finally, when they've revised our bills to have them ready, as we call it, when we get them back from Leg Council, then at that point we can ask for a legislator to submit our bill so that it then gets entered into the mix, and then it can be determined whether or not it's ever going to get to become law. And lots of people are involved in that process along the way. We have 4 separate sorts of groupings that deal with legislation. One deals with things on decedents' estates, one deals with trusts, and Jeffrey Myers, who's going to be speaking later on today, is the chair for that group. And we also have a group on guardianship and a group on advanced directives. So lots of information, and eventually, sooner or later, it comes down to a way that it can be filed and by the legislators that we're going to be using. This year we're going to be using Representative John Ray of Waxahachie. We're going to be using Senator Jose Rodriguez in El Paso, and also Representative Sinfronia Thompson in Houston. Various ones are going to support various things for us, and we'll try to get those things to go through. So, kind of in a nutshell, I wanted you to see how we got to where we are. A lot of times at this point on during the year, I might get emails from people saying, hey, we need to change this part of the law, or what is Reptil's position on this? Well, the fact is that Reptil can't take official positions because all of our positions and our package has to be approved by the state bar. And so at this point, Reptil as a unit doesn't get to do anything, which is real handy when someone asks you to support something that you don't want to support. So right now, where we are is we're going to try to get our bills passed, and that's what we're going to talk about today, at least the information that is in our bills and some of the other things that are interesting that I'd like for you to know about. The person who wrote this paper is Bill Pargaman, who's about to become the chair of Reptil. He's the chair-elect right now, and also he was the chair of ETLAC, which is what I am, for the last several sessions. And so he still spends probably more time tracking this than I ever will, and so he's put together this paper and will continue to update it. And so big thanks to him for getting this and keeping us all ready to discuss things. So we have a lot of bills, there's a lot of information. I'm going to try to go through these. I'm going to touch upon some of the ones that I think are important for you to know about. Keep in mind that none of these are law, anything can happen. So kind of in a sense I was talking to Jeff earlier today that this is kind of the off-Broadway premiere of what's going to be happening later on. And so there's going to be so we're still in the study session. So I'll see what jokes work and keep those and lose the ones that don't. So let's talk about, I'm going to go to page 5 where we can talk about the Reptil bills. And first we're going to talk on paragraph 7, which is deals with decedents' estates. So Reptil's doing a few things in the decedents' estate world. We actually have just gotten bills filed, so I have updates to this paper. I'll rattle off the House bill or Senate bill numbers if you want to write them down. But keep in mind that anything that I say here, you can easily have access to by just going to Texas Legislature Online. And you can do a search there, and it'll show you probably what bills we're talking about here if you just type in some of the search words that we have in the title. And that's a real good resource if you want to track the bills as they go forward. It also has the text of the bills that you can go to so that you can see what exactly is being proposed. So first off, we are going to be asking in House Bill 2428, and that's a new number for you, for the legislature to approve the Uniform Disclaimer of Property Interests Act. So for those of us who have to deal with disclaimer interests, we know that the current system under Texas law is a hodgepodge of statutes that don't seem to have a completely cohesive unit, and in a sense also they don't really fit together as nicely as we would like them to with federal law implications of disclaimers that are involved in certain tax situations. And so what we've done is we're overhauling the disclaimer statute so that it makes more sense and is up with the times and is also consistent with what most other states are using. So we tweak it a little bit to make it more Texas specific, but overall it's going to be the uniform law that most other states have already enacted. So I'm not going to get into the details of it. There's a lot of details that we could get into, but you're not going to be interested in them right now, I don't think. And also that the entire bill is going to be discussed in further detail this summer at the Advanced Estate Planning and Probate Seminar. So you can always look at that paper later. So let's talk about 7.2, which is what we're calling the Reptil Decedents' Estates Bill. This is the main bill. Now originally we had one bill for all decedents' estate stuff, but the legislature has what we call a one subject rule. So what they will do is if we send them something that has too many topics to it and they feel that it violates this rule, then they will carve it out and create new bills from it. So we may have started with one bill and maybe we have multiple bills now. But the one that has most of the changes to the Estates Code is the one that we describe as 7.2, which has now been assigned a bill number, and it's House Bill 2418. So what does it do? Well, all these bills do a lot of things that are just technical clarifications that we don't need to really get into detail on right now, so I'm going to hit upon the high points, the things that may be substantive changes in the law that you might be interested in. And the first one is something that I think is pretty interesting to see how this works out, and that is on reformation of wills. And to give you a little heads up that also we have a similar provision in the trust bill so that you can reform and modify trusts in a way that you couldn't have done before. Right now, the intent of the testator or settlor is usually not important if things can be determined by looking at the four corners of the document. So as long as there's no ambiguity, you don't get to go outside of the document to find out what the testator really wanted to have done in his will, which can cause a problem if, say, for example, the testator's wishes were simply not followed by the estate planning practitioner who prepared his will. You know, so maybe he got a bad attorney, or the attorney was having an off day. Whatever it was, the attorney made a mistake, and it may be that everybody knows it, that there is a mistake in this will, and because of that, the testator's intent is going to be completely ignored if that will goes through. Well, right now, unless there's an ambiguity in the will so that you can show to the court that it could mean different things, and so therefore we've got to find out what the testator wanted to do. Right now, unless you do that, then you're stuck with what is in the will. So now what we're going to ask for is for authority to amend a will or a trust if there is a scrivener's error. So that way, if the person who wrote the will originally, the attorney, if it can be shown that he made the mistake, then things can be fixed. Now, this is a big change in the law, and because it's a big change and it could be ripe for abuse by people who just want to come in and say, well, gosh, yeah, the guy who wrote the will is now dead, but I know that what was meant was this. Daddy meant to give me everything instead of giving me nothing, so please reform the will. Well, there's an evidentiary standard that you have to deal with, and that's clear and convincing. So it's a higher evidentiary burden to show that there was a scrivener's error, and so hopefully that will keep the nonsense lawsuits out of the courts. But the ideal situation to prove up a document like that, the scrivener's error, would be when the scrivener himself says, I made a mistake. So the scrivener's going to have to fall on his own sword in order to really make this reformation be done easily in front of the courts. Otherwise, the courts may say you didn't meet that evidentiary burden. So that's an important one to watch because it is a substantive change and it's going to affect all of our practices in the future. Next, who gets the inventory? On B, as you may know, practitioners definitely, the students maybe not so much, that you have to give out notice whenever a will has been admitted to probate. But you don't have to give out a notice to everybody because sometimes it doesn't make sense. Like if somebody's already received the gift under the will, why should they get a notice that the will's been probated? Or if they have a very small amount, like less than $2,000, a de minimis amount, maybe it's not worth the time and trouble to give that person that notice. So some people don't have to get notice, but the way the statute currently reads, if somebody's going to file an affidavit in lieu of filing an inventory in an estate administration, they still have to give notice out to everybody. So even the people that never knew the will was probated are right now supposed to receive information of what is in the inventory if an affidavit in lieu of inventory is being filed. What this provision does in our bill is that it fixes that so that you don't have to give that additional notice to people who never got the first notice to begin with because they have small interests or interests that have already been fulfilled. We also do several things on the rest of page 6 that are there to clarify that it is the state's policy that if somebody is going to receive something from a testamentary disposition of any sort and they divorce the person that wants to give it to them, then that person and their relatives will not get that gift. And so there's already a provision in there that we added for just dealing with regular bequests and devises and wills, but there's lots of different ways that property can transfer to people at death, and so we're tweaking it a little bit further to try to cover all those bases so that nobody can say, well, yeah, I may have divorced him a long time ago, but I'm still named in this document or named on this account, so I should be entitled to receive it as a testamentary disposition. So that includes, for example, on the bottom right corner of page 6, that account designations are not going to be effective. So that if somebody even has a payable on death to a spouse and then they divorce it, that spouse is not going to take the account. So before, since it was a matter of contract, it would automatically go to that person. Going on to page 7, the reptile bill is going to make some additional revisions to clarify that we want a system to where foreign wills that meet the requirements in that state, either to be a valid will or to have a valid self-proving affidavit, are going to be valid here in Texas, kind of a full faith and credit issue, so that we will honor those as long as they meet the requirements of where they were either originally signed or where the testator died. We've added some things already. This is there to close off all the other gaps that might have caused confusion for the courts. On the right-hand column of page 7, you'll see that what Bill is referring to as some tinkering provisions. A lot of these deal with privacy considerations, so that now that we don't want to be filing information that could be used for identity theft and things like that, we're tweaking some of the requirements so that you don't have to give as personal information as you may have had to in the past, such as you don't have to give a minor heir's age. You don't have to give a residence if there's another place where the person can accept service of process, things like that. So that'll be a good thing. Going on to page 8, I would draw your attention to what is it, about lawyer trust accounts. One thing that has happened that we've had to deal with, several of us, is that if somebody in our profession passes away and they're a solo practitioner, then they may have an IOLTA account that they had open to deal with the trust funds that they receive from their clients. And so now if the attorney passes away, that attorney can no longer access the IOLTA account, and so it can create a mess to where you have to go to court and ask for specific permission to have a receiver appointed to take over the IOLTA account and make sure that clients get their money back. Well, now we're making a provision that a representative, somebody who's already been appointed as the administrator to manage the deceased attorney's estate, can also appoint a Texas lawyer without having to go through the courts to take over the IOLTA, so that we can make sure that those monies go to where they need to go. Next up on 7.3 is something that is not a reptile bill, but is just recently filed, and it is to try to get Texas to adopt the Uniform Fiduciary Access to Digital Assets Act. So this is some cutting edge kind of legislation, and Professor Beyer has spoken a lot on this, and he's in charge of the committee that's going to be looking into this and seeing what portions of this act need to be changed, if any need to be changed. But what this is this is a way to ensure that people who had accounts, such as a Facebook account with content or a MySpace account with content, I guess if anybody still uses that, that person's content can be accessed by their administrator, so that way it's not just stuck out there in limbo. A couple of states I think have adopted that, but it's pretty fresh, so it's only being shopped around to major jurisdictions right now. Let's see. One thing that's recently filed that practitioners are probably going to be interested in is House Bill 2274. That's not in these materials. It was filed earlier this week, which changes the statute of limitations on a will contest. Right now, you've got 2 years after the admission of a will into probate to challenge the probate of a will. And so now there's a bill that would change that to 1 year, under the thinking that 1 year is enough, and so in the interest of finality of probate, we don't need to have this 2-year window. It still allows for what we call the discovery rule, where it may be that somebody was trying to hide the ball and wait out the time and therefore didn't share the information that the will was out there to people. But overall, it's a pretty big change from 2 years to 1 year, and I know that several practitioners are not going to be happy with that. And speaking of that, if there's anything that you're unhappy with or you see that you think is a bad bill, you can certainly express those opinions with me, but keep in mind that you're always free to also go down to the Capitol and testify. And several times I'm going to be down at the Capitol testifying myself, but I'll be doing it, except for the reptile bills, I'll be doing it in my individual capacity to try to carry forward information and maybe say, I've heard that other practitioners are opposed to things for X and Y. So we're not the only way to get your voice heard. You always have your individual voice, and it may be that you want to contact your own representative to say, hey, this is a horrible bill for whatever reason. Let's see. Next, let's talk about the access to intestate's account information, 7.5 on your paper. There has been some, well, over the summer, there were several meetings that I was also a part of to deal with ways to increase access to the probate system for indigent folks and other people that may not have had as much access in the past. And one of the issues that was looked at was small estate affidavits. Small estate affidavits is one where you don't have to go through probate and you can just have a small estate affidavit approved by the court if your estate, other than homestead, is less than $50,000. And so, but the problem with that is that one of the things that you have to do is you have to represent to the court that approves the small estate affidavit that there's a certain amount of money on an account somewhere. And so, but the problem is that sometimes the banks won't tell you or won't tell the surviving spouse that there is this $33,000 on account. They just like shut the door and will not talk to you. And so what this bill is designed to do is to allow and require a bank to give that information to somebody so that they can then, in theory, move forward with a small estate affidavit themselves. There are a couple other bills that came out of that work group, and we'll get to those here in a few minutes. Turning the page to page 9, beginning on number 8 is the guardianship section of the paper. And so let's first talk about what the reputable guardianship bill does. And it doesn't do too much substantive this year. So it mainly just has a whole lot of little fixes to it to try to make our practices easier with guardianships. The one thing that I think is of big interest to practitioners are going to find helpful is the letter G, which deals with safekeeping agreements. So, and for those of you who don't do this much, safekeeping agreements are what can be entered into between the guardian and the court to help reduce the bond. So that if I'm the guardian for somebody that's got a $5 million estate, well, I don't need to be in charge of all $5 million of that, and I certainly don't want to have to pay the premium associated with the bond that's there to cover those $5 million. So what I will want to do is ask the court to approve a safekeeping agreement with a bank, to where it says that the bank's going to have control of $4.5 million in this one account, and they will not release it to me, the guardian, until the court gives the okay for it. And by doing that, now I, the guardian, am only in charge of $500,000, and I can have a $500,000 bond and save the ward a lot of money on premiums. So the problem under the current law is that it seems to, it suggests that you cannot enter into a safekeeping agreement until you are appointed the guardian. And so you don't get to be appointed the guardian until you have the letters issued to you. And if in theory, as soon as you get your letters issued to you, you could run out of the country with $5 million, courts feel that they need to put a $5 million bond on you originally, and then you go back in and ask for permission to enter into that safekeeping agreement. But by that time, the bond premium has already been paid. It can be a pretty hefty bond premium for larger estates. And so what we're trying to do now is making a provision to where you can enter into a safekeeping agreement prior to the qualification, so that we can have that agreement so that from the beginning you only have to have a $500,000 bond instead of the big $5 million bond. So that's going to be real useful for those of us who deal with large guardianship estates. Another nice little tweak is going to be found in J and K, where it's going to allow for the court to appoint an ad litem to have a minor's property interest go into the registry of the court, the value of it, without a guardianship. Right now, the statute provides that only certain people can ask for that, such as a parent or managing conservator. But if there is not one, and there needs to be property sold and have those proceeds deposited into the court for the minor, this way a court can say, ad litem, I'm going to put you in charge of doing this, since that way you can ask for the relief, since there will be somebody there to ask for the relief. So that'll be that'll be helpful in certain situations. So that's the reputable guardianship bill. Some of the other things we've already seen filed that we're going to be hearing more about are also on this page. So if you look at page 8.3, what that does is that now asks to have criminal background checks done for family members. Right now, if you're a family member who becomes a guardian of a ward, you don't have to go through a criminal background check. If you're a non-family member who's going to become a guardian, then the clerk has to do a criminal background check. Not anything too specific. They run information through a database, and from what I understand, it's not that onerous of a task. But what it's there for is to make sure that you don't have criminals in charge of wards. But it's been okay to have a family who's a criminal in charge of the ward. So now what this is to try to level the playing field. Now, it may end up causing some confusion or problems because often we find out that family members might have a bit of a history. You know, it may not be something that they are currently involved with, but it may be an issue. You know, but so that's what that purports to do. And we'll see where that goes. Let's see. Turn the page to page 10. I want you to look at page 8.8, which is another nice tool for ad litem's in guardianship cases. Usually right now, when you get when the judge signs an order appointing an attorney as an ad litem for a proposed ward, it will say that the ad litem has the powers to look at the ward's medical records and get access to the ward's financial documents. Well, what this provision would allow is this would compel a bank to give that financial information when requested by a court investigator, including an ad litem in a guardianship matter. So that way, sometimes the big banks will say, well, I don't have to live up to that, but now this helps the court and helps the ad litem force the bank to live up to what they should be doing to begin with. Going to the right-hand column of page 10, now we'll talk about trusts. So we've already talked about decedent's estate and guardianships. Now we're on the third subject, which is trust. And the trust bill has been filed, and it does several things with lots of provisions, but we'll talk about what is substantive and what isn't. The first thing that it does to be aware of is that it helps clean up our directed trust statutes. So directed trusts are ones where you may have a fiduciary who has the ability to appoint other fiduciaries to tell them what to do, or that different fiduciaries have different jobs. And what we've done is we've cleaned up those statutes because we've seen through trial and error what some of the problems are, and to clarify who has what responsibilities as a fiduciary. And that covers the common divisions of there being a distribution trust advisor, an investment trust advisor, and a trust protector. So there are different hats that one can wear as a fiduciary, and this bill clarifies that you're really going to be responsible for damages if something happens as a result of you making a mistake while you're wearing your hat. So if I appoint somebody else to do something and that person does something that they should not have done, then I might be responsible if I picked somebody incorrectly, but one of the other fiduciaries that's involved in that trust would not be responsible because it was under my supervision that the mistake occurred. So that's what that tries to address, among other things, and there's lots of details there if you want to take a look at it. What's going on to page 12 is the second big thing that our trust bill does, and that's that it helps revise and tweak the decanting statute. And one of the students is going to be giving a presentation about decanting a little bit later on today, and so I look forward to hearing that. What this does is there's going to be several changes because the decanting statute was a new statute as of last session. We now are we're feeling out where the bumps are on it and trying to fix anything that needs fixing. One thing that it does do is it provides some additional powers for the new trust. And for those of you who don't know what decanting is, I'll take a step back. What that is that when you've got a trust that's got some problems in it, usually administrative problems, and instead of modifying it, if the trustee has the power to decant it, then it can essentially move everything from one trust into a new trust that has been created to solve the problem. So just like you're pouring a bottle of wine, you're decanting it into another trust. And so we initiated that in the last session, and now we're doing some tweaks to it. One of the major tweaks is that now if the original trustee had full discretion on being able to give out distributions to certain numbers of beneficiaries, then he has more power to modify some of the distribution provisions in the new statute. Before, it was essentially that you couldn't do anything that had any real effect to change Trust A to Trust B. that had any kind of meaningful financial impact to the beneficiaries. But now, if this person had full discretion to begin with, they can make some changes that will hopefully better serve what the settlor originally wanted. So several provisions are going to try to fix that in the decanting statute. On F of page 12 is a reference to the reformation of trust. Just like I said before earlier, that now we're going to have the opportunity, hopefully if this bill passes, to address mistakes in a trust if there's been a scrivener's error and if we can prove it up by clear and convincing evidence. So now let's go down to, you'll see at 9.3, now these are some other bills that have been filed by other people. Recently there was filed a bill to ask for the Texas to be able to create self-settled asset protection trusts. And so for those of you who work in this area or are familiar with spendthrift trusts, what that concept is that if you're going to put assets aside so that they cannot be attached by creditors, you yourself should not be able to have control over those assets because essentially you're having your cake and eating it too. But certain states, such as primarily Alaska and Delaware, allow for self-settled spendthrift trusts to where you can have a trust that is created where I can put all my money into it and I can still be the beneficiary of it and still have lots of control over it and get creditor protection. And so other states will do this and often as a way to get trust business into those states, because one of the requirements is that you have to have a trust officer or a trustee that is located within that state. And so this is kind of a surprise to us at Reptil when this was filed, that we didn't know anybody was wanting to try to do that in Texas, but that's what this does. The proposal as it stands has many problems with it. It probably needs to be tweaked if it's going to go anywhere, but we'll see if it does. Creditors are certainly not going to want to see that happen because it can leave a lot of creditors out in the cold and gives the person a whole lot of additional new powers to help prevent creditors from receiving the income that they may be entitled to. So it's going to be interesting to see where that goes. Next, go to page 13 and number 10, disability documents. And so this is our fourth Reptil section. This is the one that deals with powers of attorney, both medical and financial, and directed to physicians. We're still waiting to have those bills filed, so there's not even anything you can look at online, but what we are trying to do, the big thing that we're trying to do, is to try to move forward in the financial power of attorney arena to where we're trying to make the financial powers of attorney that we all prepare more useful to the agents and to accomplish what the principal always wanted to have accomplished, which is to give that agent sufficient power to do things. One of the issues that has been faced in the past is that third parties may say, no, I'm not going to honor that power of attorney. They may not even have a good reason, because they don't want to involve themselves in any risk that's associated with accepting a power of attorney. They may just have a blanket refusal to never honor them. And so we don't like that. We want to know that if somebody comes in and we prepare a power of attorney for them, that they're going to be able to use that at the bank if their spouse or the principal becomes incapacitated. And so what we've tried to do is try to build in some safeguards that would ensure that it would be accepted, while at the same time making sure that financial institutions wouldn't think that they were trying to have something forced down their throat. And so if you look on page 14 near letter K, that is kind of the meat of what this bill contains. The big substantive change is that it's going to give a little bit of teeth to the new power of attorney. Not too much teeth. It's not going to be anything that anybody should complain about if you're a bank. But what it does is it has it if a bank is asked to accept a power of attorney by somebody, they can then request that the agent certify something in writing that it's effective, and also that the bank is not going to be held liable for accepting it on the basis of validity. So that essentially that if I am an agent and I'm saying, here, I'm certifying that this is still valid, you as a bank cannot automatically just say, no, I'm not going to accept that because we don't accept powers of attorney. Now, there are reasons to not accept powers of attorney, and those are listed on page 15. Lots of reasons not to accept a power of attorney. So if a bank has any reason to believe that the person who is offering the document up is a bad guy, or that it's not something that the principal wanted, then the bank can certainly refuse that. But if they don't have any reason to object, then they need to be able to accept that power of attorney. And so that's going to be a big change and a very useful change if we can get that adopted. Also on page 15, it discusses some other things where we're going to clarify that certain powers can be added to the standard statutory power of attorney language if it's something that the testator or something that the principal wants to have happen. So it's going to give kind of even additional authorities that a lot of us include in our documents as it is, but this specifies and kind of tells the testator, hey, these are some what we call hot powers, and so if you want to add them, make sure you know what you're adding, and it gives you greater opportunities to give your power of attorney additional strength. On page 16, one thing that it may be the way we sell this whole power of attorney bill is that it gives the agent the authority to provide for the care of the principal's pets. So, you got to throw some cute puppies at the legislators, and hopefully that'll be enough to get it passed through. So no, but obviously that's something that a lot of us we see as practitioners is that people are worried about what's going to happen to my animals after I pass away. And right now, it's not clear that the power of attorney, that the agent under that has the ability to act on behalf of the principal. Of course, if the principal is deceased, the power of attorney is invalid. So what I meant to say is, if the principal is incapacitated, this way the agent can come in and make sure that the pets are taken care of. A little bit farther down on page 16 is the medical power of attorney statute that we're going to try to tweak a little bit. Not doing too much to it. What we are doing is we're clarifying that if a medical power of attorney has been granted to somebody and then there's a divorce, then the ex-spouse agent no longer gets to be the agent. Sounds like that would be a good thing. So that's one of the things we're doing there. We're also clarifying that you can have co-agents under a medical power of attorney, which is not specified in the statute right now. And a lot of times people will come in and say, well, I want both of my daughters to be my co-agents under medical power of attorney. And we have to say, well, we're not really too sure the statute allows that. The hospital might, but the statute doesn't really, so we just need to pick one. So pick your favorite. So there's that. We're doing a few other changes, but I want to go to page 17 to discuss some of the other bills. One that I think is important to look at is 10.11 here, which is a recently filed bill dealing with mental health treatment. So right now, if I've got my wits about me, I can sign a declaration of mental health treatment where I can say what I want to have regarding mental health services. And so say, for example, I could sign a treatment that says, I don't want to have psychoactive drugs administered to me for any circumstance. Well, sometimes sometimes it's a medical opinion that certain drugs and certain treatments are absolutely necessary for you to ever regain capacity if all of a sudden you go through a mental illness outbreak. And what this bill is doing is it is saying that now, if somebody has said before that they don't want medication of any sort, now the hospital can refuse to give them cannot give them that medication, even if that's the only way to get them better, unless they can show that the person lacked the ability to sign the designation of mental health treatment back when they signed it. So what that can have a tendency to do is it might hinder the efforts of trying to get people well that get pulled in on mental health commitments. So it's something to look out for. Page 17 also deals with non-testamentary transfers. One thing that's going to be heard in a hearing on Monday at the Capitol deals with transfer on death deeds. And so this is something that was designed to help with some more of the low-income Texans that don't necessarily avail themselves to estate planning. So this is a way that somebody can do a simple sort of estate plan informally through a transfer on death deed, where it specifies under what circumstances that a deed can be done so that it passes non-probate, so the real property passes non-probate, at the death of the holder. And so that is something that we've been working on that all summer, and so we'll see how that plays out in the legislature on Monday. But that is something that is probably going to be a reality by the end of the session. One other thing that Reptil is doing on the bottom of page 17 is regarding exempt property. You go to page 18B. We're trying to increase the exempt personal property limit. It hasn't been adjusted for inflation for a long time, and so now what it would say is that a person's exempt property, that is exempt from creditors, it goes up from $60,000 to $150,000 for a family, and $30,000 to $75,000 for a single person, with regard to the exemptions that are relevant after somebody passes away. So then on page 13, we're going to talk, there's a little bit of information about jurisdiction and venue. Mainly we're just kind of cleaning things up. One thing that we needed to clean up in the guardianship bill is that it currently refers to the proper venue for an application to transfer a foreign guardianship from a court in which the ward resides. It talks about that. Well, no wards reside in the court. So, and if they do, they don't get to reside there for very long once the staffers find out that they're there. So now what this does is it changes it to clarify what it should have said, which is that it deals with the venue for a person who resides in a court in the county in which resides in the county in which the court is located. So we're fixing that up. The bottom of page 18 to the right, there you'll see 14.1, promulgation of will and probate forms by the Supreme Court. For a long time now, we've been trying to deal with some concerns that there should be forms for simple probate matters so that people who were trying to do some self-help would have better guidance as to doing that self-help and not clog up the court systems and make everybody's life miserable in making mistakes. And so we're taking a further step with this what they've done here is this is a bill that's going to ask the Supreme Court to appoint a task force to come up with certain forms that would then be able to be used by pro se people. And this would be for things such as hopefully simple wills and powers, small state affidavits and muniment of title. And so that's something that you'll see several years from now when those forms finally get completed and approved by everybody. So I know that I've covered a lot of things today. Keep in mind, none of these are law yet. So the paper that you will see after June 1 when the legislature ends is going to be a whole lot different from what you've heard today. Hopefully it'll amount in some good things and not too many bad things. And also, just recently this week, just the last bit of information is that Jasper was named the official butterfly capital of Texas. So way to go, Jasper. Thank you. Oh, thank you. Appreciate that. Yeah, thanks.
Thank you, Mr. Hopper. We're now going to take our first break of the day. We'll come back here at 10:20. We have a quick announcement from Jesse Beck.
Okay, guys. We had a bunch of little fires pop up this morning. I am wearing my firefighter socks today, so I'm putting them out left and right. The first thing is, I've already told you that Jim Hartnett and Jerry Byer were switching spots. So Professor Byer will go at 10:20. Unfortunately, Darren Moore's flight was canceled, and he's not going to make it at all. But we have a backup plan. Professor Byer is going to give a second speech, and what he's going to do is there are EPJ members passing around right now. There is a survey. He has 5 speeches already prepared listed. And you guys get a vote on which ones you want to hear. We'll collect them at the end of the break, and we'll tally the votes. And at 1:45, he will give the second speech, which means that Mr. Jeff Myers will now be speaking at 11:25 in Darren Moore's spot. So just to reiterate, Professor Byer is going at 10:20. Jeff Myers is going at 11:25. Jim Hartnett's going at 12:40. And at 1:45, Professor Byer will give the audience choice speech, or presentation. So vote, and we'll collect them at the end of the break.
You probably want to go to a different view.
It's okay. I know where Byers is.
I'm saying, do we even want to change it around so we don't have to mess with it ever again right now?
He doesn't have any slides. I'm just putting up his name slide,
Okay.
and we'll go back up to the
All
top.
right, we'll have slides for the alternative presentation.
All right, perfect.
Okay, well, I'm going to need those soon.
We can sort through that.
Yeah, here it is. Yeah, I know. It's wrong. It's 11:15. Yeah, she gets 10 minutes. Yeah. Yeah. She's getting 10 minutes.
All right, where's the other?
Do you want this?
Yeah, I want that.
Okay, which number is that? 1. That's 1.
Oh, yeah.
Okay, where are we going?
I have no idea. He's supposed to be out there. He might.